Welcome to our webinar. This video was designed to check the name, are part of our family, our client. And some are new and welcome to the family. It's been an honor to be associated with you for such a long time. We've been doing this, we used to do before live. Now we plan to do this kind of webinar at least once a month, at the latter part of the month, which will be helpful, I assume, to all of my clients and friends. And looking forward to discussing all the burning issues which might be coming very soon under the new Trump administration. Having said that, all of the IT companies, IT consulting companies, or mid-sized, small-sized companies have concern, am I going to be able to survive the second Trump administration's restrictive immigration policy against the consulting? So if we look at the past, we can see there is a pretty big attempt by the Trump administration which tried to increase the prevailing wage. Prevailing wage is the core of your business. So if you have to pay level for wage, there is no more money left for you to run the company. So the consulting company's model really cannot survive level 4 prevailing wage. So there was some lawsuit, and that resulted in on hold on a particular provision of the increase of the prevailing wage, which was supposed to be increasing more than 25%, right? So we want to discuss that matter as well. In addition to that, we'll also explore the H-1B Modernization Rule. Under the H-1B Modernization Rule, which came on January 17 of 2025, there are a couple of good news, right? The good news is the H-1B gap has been extended from September 30 to April 1. And also, this is the Modernization Rule has a lot easier for non-profit companies to qualify for capping H-1B status or the associated with government facility. So those are the now the bad news is the most critical part of H-1B job is hiring expertise for professionals or accountant or business studies or doctorate, whatever you have. So prior to this organization rule, you could focus on some kind of a major study and make an argument for the reason that person might be qualified by virtue of taking months of courses, months of classes, and then get on the approved. The new rule, they created a matching up situation. Means the degree and the proper occupation must have directly to the job. So if I'm applying for a construction engineer, the person must have a civil engineer. The other degrees are going to qualify. Is it working here? Hello? Is it technical problem?
Okay.
Can you hear? Okay. Well, there is a though.
Yes.
People who are listening, can you check?
Yeah. Let's do it.
Okay. Is there an echo on the screen?
Screen.
Okay. Thank you. Just want to make sure people are not getting echo. Okay. So what I was saying is the degree must match. If you compare to a developer job, the person have qualified to a quantitative discipline, which is could be electrical engineer or electronic communication engineering, or could be math for that matter. I mean, I have cases that are in the past, all sorts of quantitative disciplines, even chemical, because the folks for computer courses there. So that those days are over under the new rule. So this year, which we're fighting, you must get a combo effect. If a person doesn't have a directly related degree, if it's a directly related foreign degree, you still need a technical evaluation. So if you have a degree which is somehow related, then you need 6 years of experience in that related field and get a combo eval from university professor and then get it. That is going to get approved without getting a NOID or RP so far as qualification is concerned. Now, I'm going to show you one of the letter I received recently, which was filed after the January 17 of payment processing. So there, what it say is notice of intent to deny. So we have not submitted, uh, combo event. We have submitted just a regular event. But the USCIS issued not an RFP, but notice of intent to deny, which means they only give you 30 days or 33 days. So within this time period, now we need to put together the job experience letters, qualifying job experience letters, and then you repeat and go to a university professor. We have to write our ability to grant credits for those and get this combo event. So in this particular notice of intent to deny, only the letter reads in part, it says USCIS interprets the term degree to mean not just any degree, but one in a specific specialty that is directly related to the offer position. As I just said, matching. So they want to have a degree which has a direct relevance to the job being offered. So this is the NOID which came recent, right? This is the H-1B Modernization Rules impact. That is the NOID RFP. In the past, we used to get RFP in those type of cases. If it is very far away. Now, this is a quantitative discipline degree, even though it was pretty much close to those electronic and communication engineering. For a software developer, but they didn't buy it. They say, you need to provide me a directly related degree to the offer of the pitch. So we're working on it. We have, I think, 10 days or so left, and we need to respond to this. So this is the situation, right? That's the number one, matching, specialty occupation, degree, and the offer job needs to be matched. So now, the second issue is bona-fide income. So if we look at the history or the past, the itinerary rule as well as IT service employee requirement, the dial rule have been eliminated. However, the H-1B modernization rule requires you to have a bona fide employment. What does bona fide employment mean? Bona fide employment means you must have an employee relations. You must have a contract with this employee. So it's still we're singing the same song from a different field. Nothing must have changed. So you still need to provide an employment contract to prove you have a control over. Now, the second thing is, how are you going to prove that, right? The bona fide relationship. Which, if you are facing a guy with third party 25, you still need, even though you're not providing itinerary, or you are sending the guy to the end client, that means you still got to submit contract, PO, and end client letter, confirming there is a bona fide employment at the end client side. So even though the itinerary and the employee-employee relationship have been taken out by the modernization rule, but the impact of the same activities remain alive. In this context, what we need to do is prepare. We need to prepare ourselves. We need to prepare ourselves to the best of our ability to deal with these issues. How to survive and file H-1B escape season successfully and get the job done. Filing H-1B alone is not enough, right? So let's say you pass all the muster, you pass all the tests, right? You provided relevant or qualifying for that specialty occupation, you have a relevant degree, you have an end client, or you have ability to prove you have an in-house project, you submitted your incorporation certificate, your tax ID, your bank account, bank statement, your lease, your quarterly payroll, and or maybe marketing plan or product brochure for your software or other activities which you do in the company. So you prove bona-fideness of the job. You prove the employee is qualified, right? So while this is going on, you chose level 1 or level 2 LCOA, you filed the H-1B, now the H-1B is pending at the USCIS. Now the USCIS may do a visit to you on and off. Under the H-1B Modernization Rule, it has made rules simplified. The USCIS officer can come anytime, and if you do not cooperate with the USCIS FDNS officer, the case can be denied. Or they might issue NOID, a notice of intent to deny. While the case is pending, after the case is already approved, they will issue NOID, notice of intent to revoke. So now, it was an end client thing, let's say. They went to the end client, talked to the end client manager, and who said, well, this job is pretty high level job. It requires, we advertise, it requires to have 7 years experience. On lo and behold, you had filed LCA with a level 2 job, or level 1 or level 2 age, right? And also you have provided job duties or a qualification requirement as a bachelor's degree and less than 1 year experience. So there is a mismatch now. Mismatch of job duties, wage level, and which came from the horse's mouth with the end client. Now the auditor is going to believe the end client's story rather than your story, which you wrote on your H-1B petition letter, as well as on the 35 LCA. So these cases we are seeing right now. Like, I'm dealing with right now 3 cases for 3 different IT consulting companies. Exact same scenario. Went to the site visit, client said something, and then when they talked to the H-1B employer, he said, according to the H-1B petition, he said it requires a 1 year experience, bachelor's degree. So, see, I'm bringing everything in house, right? Now, you file the H-1B in compliance or within the framework of the H-1B Modernization Rule, but now you have FDNS side visit. While the case is pending, how do you deal with it? Officer comes, knock, knock. So do you have a assigned manager, HR manager, who has been assigned and prepared by the attorney to deal with the FDNS officer? Offer cold, hot drink according to the season, put the officer in the conference room, don't let him go on inside for no reason and taking pictures all over the place or interview other employees. There is no reason for them to do that. They are coming here, they are fact finders. They are coming to talk to you about the material which was provided to them in the form of I-129 LCA petition letter and the supporting documentation. So now you want to have that designated person in the company. Designated person takes to the room, gives them there. Now they're going to see, okay, I want to know what's going on. I want to see this guy's H-1B file. My recommendation to you, everybody who is listening right now or will be listening in the future, make sure as a H-1B dependent employer, you must have in public access area, public access. Public access file is not used there, right? You have a certified LCA, signed LCA, you have a prevailing wage, you have a benefit summary, you have an actual wage, prevailing wage, LCA acknowledgement receipt, things of that nature, along with the posting notice. So, did you post LCA at the end client site? If you were not able to post the LCA, did you make an attempt to post the LCA at the end client site? Right? So, I will discuss this case law down the road. What is the value of making an attempt to post the LCA at the end client site versus not doing anything? you have an obligation under the H-1B laws to post that LCA not only in your business premises for for 10 business days in two contiguous locations, but also you need to post at the end client side. There is no compromise. At the end client side for 10 consecutive business days in two conspicuous locations. One could be break room, one could be, lunchroom, and then maybe reception area, any area where all the employees have access as they go in. So now you have this situation where you have that you need to have a public access file. Those are the only documents, right? Now I want you to create FDNS H-1B compliance form. What is going to consist of in the H-1B compliance form is entire H-1B petition, LCA petition, passport visa I-94, your degree on the transcript, end client letter, contract, PO, everything related to this H-1B worker. Put it in there. His W-2, his recent pay stub. Make sure now you gotta pay attention, right? You're putting pay stub, check on the pay stub. On the address of the employee, if the employee is within the same MSA of the original H-1B filing of the LCA location, is he outside of the MSA or outside of the commuting distance of 50-mile radius, right? So we gotta pay attention to those details. And if there is a problem, you want to fix it. It's like a self-audit. So once you do this, you have this documentation in the file. FDNS officer comes in, you pull it out, you print it, you want to see public access file, there is a public access file, you want to see compliance folder, there is a compliance folder. All the T's that cross, I's that dot. You are in the same situation. There is no penalty per se. So, but this thing, H-1B compliance folder, has to be shared among three people. HR manager designated by the company, which is going to be the FDNS officer, who will be answering the questions of the FDNS officer, number one. Number two, H-1B worker, him or herself. He or she should know entire H-1B petition job duties, and she needs to say the truth, whatever is on the job duties, the LCA. And you need to tell the employee, if you move out of the 50-mile radius, they need to let you know, you need to file amended H-1B petition. See, a lot of things are coming up here. Now H-1B amendment is up. When is the material change? When you have to file H-1B amendment? See, as I talk along, we're going by topic, and then these things are coming out of nowhere. So, 50-mile radius, let's see, it was within 50-mile radius. You are fine. You can say, okay, everything is legit. You have this compliance folder ready to go. But now you can know guy has already moved to Texas 3 months ago. There is no excuse now. You are in a default because you should have filed amended petition at least 2-3 months ago. Keep in mind, there is a short-term placement rule. You can place a worker without an LCA up to 30 days. In aggregate 60 days. Okay? But don't use that all the time because there are some loopholes you need to be able to comply. Now, the guy moved to another client side on the same job, similar salary, but 20 miles away. So, quote unquote, he's or she is within the same site. You don't have to file H-1B amendment there. Now, what you need to file is you gotta post the old LCA or old or new notice of posting to the new job site, which was within that 50-mile radius, and get a written confirmation, either email or the signature from the new end client manager or the HR folks, stating the fact that they did post this LCA for 10 business days in two conspicuous locations at the new job site. If you cannot do this, you cannot place this worker. This placement has to start on the first day of the worker's before the war was Tuesday, you see. So all of these compliance related documentation, you put it in one folder, you say, officer comes in, FDNS guy comes in, DOL guy comes in, you are ready to deal with it without any question. I guarantee you, no doubt about it. So make sure you're gonna be ready for these H-1B compliance regulations as they come along. So I gave you synopsis, right, on the H-1B Modernization Rule. Another thing I've been hearing from clients, everybody calling me employers about the H-1B registration rule. So these are very simple H-1B registration rule. What you need to understand is if you enter into the US with a valid visa, you obtain a visa at the embassy, you didn't cross the border as if you go wide, enter without inspection, and you got the CBP free, and visa was given to you at the embassy, you do not need to, or you are a green couple, you do not need to do anything. Sit back, relax, and carry that document. Just save it in an iPhone or whatever phone you have. So this way, if this police pulls you over, US immigration folks, ICE pulls you over, you can present it. That is your legal obligation to carry the registration document. And your I-94, or if you had not registered, only group of people in our corporate setting who haven't registered is age 4 below 14 because they did not give a finger before. So those folks want to register when they cross 14 within 30 days. Then everything is fine. The biggest hurdle you have is updating your address within 10 days. Before, this law was not active. It was dormant. Law was there, but it was never enforced. I think it was enforced around 2001, I remember. So 2001, they couldn't find any way to deport people of some Middle Eastern or some other South Asian countries. So at that time, they had used this carry level law. So you fail to update your address, and then you are subject to deportation. So on the registration side, you have up to 6 months jail and up to 5,000 penalty. Where on the not updating your address intent with the intent of deceiving or defrauding the US government, or you have criminal intent, then they can deport you. So be careful on to complete both the time. So we want to help our H-1B employees and the employer. We want to notify the folks to comply with the regulation all the time. There is no excuse about it. Okay. So now we covered this area, right? So I'm thinking, what did I put in question and answer form? So I'm going to ask one of my associates to shoot me a few questions, and then I will try to answer the questions. And if your questions are not covered, and you can bring it in Q&A session. What do you think, gentlemen? Hope you will enjoy this. Okay, could you please ask a question for me, sir?
What are the major changes introduced in the H-1B Modernization Rule effective January 17, 2025?
We just went over. H-1B Modernization Rule, which says the good news where cap gap extension up to next April, and then non-profit have an easier time to get cap exempt status, but H-1B companies are in trouble to comply with the Bona-Fide employment as well as the matchy specialty accommodation. Shoot me. When I finish the answer, you ask another question.
How does the modernization rule redefine the term specialty occupation and what evidence is now critical for compliance?
I mean, see, H-1B visa, or the H-1B job, we have been able to prove disjointed qualification and experience holders in a different format and convince the officer, no, this person has the ability to perform the job duties by virtue of his degree, his work experience, his coursework in an unrelated degree. So this combination of factors would have been a crucial element in getting H-1B approval in the past. However, as I said before, now we have to bring home a direct relevance. to the job. If you cannot do it, I guess H-1B will be in trouble.
Under the modernization rule, what factors are considered in determining whether a level 1 wage can still meet the specialty occupation requirement?
See, level one wage been an issue not only now, it was an issue during the post-Trump administration. So the USCIS position is if a person needs a total supervision, because level one is a person who is working under the supervision of another person because he has or she has minimum qualification to meet that criteria. So their thought process was it is not a specialty occupation. Level one should not be approved. But we got that. There was a situation because if a job requires a bachelor's degree, it should be considered a specialty occupation, even though it's level one. We fought it. I wrote 20 pages brief, analyzing various case laws and convincing the USCIS level one can be approved. I don't think the new Trump administration is going to honor this, my writing or brief this time around. So my recommendation is, please be aware. Do not have any remorse of choosing level one. And if you are not able to get through this whole law and the H-1B gets denied due to the level one, obviously you can appeal, you can go to the federal court, you can go to AAO. The chances of coming through those jungle is a long, long, long road. And the end result is very, very, very unpredictable. So my recommendation is please use level two review and prepare employee and project manager and yourself to be on the same page and have an FDNS H-1B compliance folder in the company as I just described.
What is the new impact of material change and when must an H-1B amendment be filed into the modernization rule?
Well, the H-1B has a lot of variables, right? It's a moving target. Guy was H-1B in 1 year, he was a software developer, maybe he went for a different role, which is sort of half software developer, I manager. But you have here, you want a different kind of site. Your requirement is different, right? You haven't filed a million petition. If you had filed a million petition, then everything is incorporated there. We'll file a million and incorporate. I'm giving you a scenario where it was within the same MSA. Guy went there, he's in a kind of mixed role. So whether he's IT project manager, IT project manager also does the design development, testing, coding, implementing and troubleshooting software applications. So it could be or supervising team members, right? So it could be in different areas. You gotta see this black and white. Is it gray? Is it black and white? So H-1B amendment is needed, in my opinion, when there is a material change. Location change, number one. Location change outside of the embassy, metropolitan statistical area, or commuting distance. You must file H-1B amendment, number one. Number two, there is a, or you are not able to post the LC to the new job site. I want you to still file H-1B amendment. At least you have something to reflect. Well, I mean, I tried to comply with the LC posting. Or you can remain with the attempt to post the LCA and keep those documentation in the email you send to that new client. Could you please post these? Or you can even ask the new employee to post in your bulletin board and take a picture. Something. I want you to have something with you. Just do not sit blank. If you are blank, then file amendment. Now, number two, job duty. Salary change. Maybe it's more than $30,000 or $25,000. Situation like this, do file an amendment petition, right? So you have salary change, job duty change, location. Those are the critical things I see.
What documentation is required to establish bona fide employment for an H-1B worker at both in-house and third-party sites?
Okay, let's just start with the what is a bona fide employment? What is a bona fide employment, right? Bona fide employment, as I described before. I knew this guy is going to ask a question. So the bona fide employment for accounts would be proving the company is bona fide, number one. So you, the form of your corporation certificate, maybe your tax return, your bank statement, your lease, your quarterly payroll, and maybe the product brochure. That should suffice to justify there is an entity which requires services with H-1B worker, right? You should be able to convince them, depending on the context of the job being offered and the context of the business. Now, the second part would be when the guy goes to client side. Most of our consulting companies, we place the guy at the client side. In that scenario, modified employment, you can create through the employment contract with the employee. Make sure your employment contract, I'm seeing a lot of things in my 25 plus career of doing this, 7,000 plus H-1Bs, a lot of times. A lot of times, you terminate the employee, you haven't notified the employee properly, there is no proper termination, now there is the issue of backwages. So have that in your employment contract. Write a clause. I have received an offer of return transportation ticket if and when my employment gets terminated. The company shall provide a return ticket back to his or her home country, and the employee has to claim this benefit. Within 1 week of termination, the employee forfeits his right. Integrate that in your employment contract. So a lot of issues of this termination protocol could be avoided just having that, and you will save $100,000. If there is a guy coming back to you after a year claiming there was no bona fide termination, right? So do all of these matching things. Okay, give me that slide again.
How does a staffing or consulting company prove supervision, control, and the right to terminate an H-1B worker at third party site?
See, going through this story again. So that employment contract should also have how will you manage when you send the guy to a client side? You write a protocol into your employment contract. How do you manage? You're going to say there will be a site manager who will be responsible for monitoring you and supervising you and assisting you in performing your job duties at the end client side. So you put that into the contract. But also, you need to have in the form of end client letter. The biggest thing you need to claim in this situation is you have signed the contract in the form of a 99. It's independent contractor agreement. So you need to make a note of that. You need to say, because of the nature of the contract, there cannot be an employer-employee relationship between the end client and your H-1B worker. That will be in violation of the contract itself. All these legal nuances, you need to explore and integrate this, being a cohesive contractual obligation related documentation, which is going to help you. All of you there, I won't have time right now to help you because of the cap season, but when the cap season is over, send me your current employment contract. I can edit it for you. Employment contract, you need to make it the contract return, which specifies the employment contract, right? But they might not know all these integration nuances, which they need to integrate it. So it will help you when there is a litigation for could be for liquidated damages or any other contractual violation, non-compete, non-placement, all issues are there, or bona fide termination for that matter. So it will help you. You will be asking the question to me about bona fide termination, I'm sure, later on. I'm going to talk about bona fide termination right now. Keep shooting me the question, please.
What consequences can arise if the USCIS determines that bona fide employment was not properly established?
I was right on the money. So, in order to have a bona fide termination, what you need to do, right? You decided, guy had, H-1B terminates every 3 years or less amount of time, whatever is given by the USCIS. So before that expiration of that H-1B I-797 day, if you terminate this employee, you gotta do three things. One, notify the employee in writing, either email or certified mail. Number two, you must withdraw that H-1B. Number three, you must offer a return transportation ticket to this employee to go back to his home country. If you fail to do these three things, you're doomed. You will not survive. You will need to pay backwards. So they have case laws after case laws after case laws. Let me see if I see the case laws here. See, let me tell you. There is a case law, right? I'm just going to tell you this is a wage obligation. Vice Baku versus Mismatch. Employment starts with employees available for work under control. What does that mean? Employee comes in from India or China, joins you, and you don't let him get the I-9, but you take his resume and you start to market. You send email to the clients. And he also gets the email for interview. He is already your employee. Whether you sign I-9 or not, doesn't matter. Your obligation begins. But people who come to the US, they have to start their employment within 30 days. After 30 days, they will have to start. Before 30 days, employee could take a very good his sister or brother in California, it's okay. So long as document, right? He requested. And you didn't market this person. So that is the start date when it's available. Wages go from that moment project or not. Whether there is work or not, it doesn't matter. That's what the judge is saying at the ARB level or the LZ level. Availability for triggers the wage obligation. Pay wages once the worker reports availability. He or she wants. So the payroll coming from overseas within 30 days. Changing status here within 60 days. You must run a payroll. If you are not running, terminate that issue. Otherwise, you will incur wage obligation and your employee is not going to cooperate. It will be a problem for you and your third party. Wage obligation. Amkel Group versus Yom Ma Hakon. This is a Thai name. Termination requires notify employee, notify USCIS, offer transportation. I already told you. Until then, employer liable for wages. Take away, document all steps of termination. Wage obligation, administrator versus government training. It is a case law again. Employer must pay per bench time unless valid exemption applies. So now, let's talk about it. A lot of companies might be put on bench. So if you just put on bench, you're not going to get off the road. So you need to make sure you have proper documentation. There is an unpaid leave request originating from the employee and you approving this event in a real time. Employee requested by email, you approved by email. Or there is a form, scanned, signed, jotted, provided to the employee. Document. Voluntary leave disability may exempt employee. Employees overseas, even employee go overseas, get a letter from them saying that they will remain on unpaid leave. You're not going to pay unless there is a vacation money to be paid to this employee. Pay during project, yeah, on this you can document. No bench, right? Third party, right violation, NOID revocation. Missing and client letters, misrepresented duties, unposted LCA. I already talked to you about the unposted LCA. LCA needs to be posted. Oversight cheating requires LCA and amended P. Refusal to cooperate with site visit can lead to penalty also. So should be another question.
What key evidence can be used to prove that a position qualifies as a specialty occupation?
Well, first of all, you got a tool a job zone 4 level, right? On one hand, job zone 4 must be there. If it's a job zone 3, USCIS is not going to be most of the time. Under the Trump administration, most probably 100% of the time. They will not agree to give you a benefit of the doubt, say, okay, this might require a 4-year bachelor's degree, even though this job is falling under job zone 3. If you look at the one end, your computer job, computer systems analyst, you have job zone 4. Now it's job zone 3. Computer systems engineer also used to have job zone 4. Now it is job zone 3. So it is all over the place. You gotta choose minimum job zone 4, number one. Number two, that has to be, if you are working in-house, you need to document that, right? How complex these job duties are. If you're hiring a job for accountant, the job duties should not sound like accounting clerk. It has to have a job duties of analyzing financial statement, preparing balance sheet, profit and loss statement, and variance analysis, things of that nature. You're hiring for IT administrator, right? It doesn't sound like IT support analysis, which has a job zone 3. So it should be a network administrator job. So you gotta pay attention to those details. Qualification matching, job duties matching, LC code matching, SOC code matching. There's so many moving variables. Everything has to come together to have a successful outcome of the H-1B approval.
How can employers address situations where the H-1B worker's degree is not an exact match to the job title or job duties?
Well, that is employer and employers have to work together in finding out the nuances, how you could prove the industry standard, the complexity of the job duties, and it might be your tradition also in the company to hire a bachelor's degree holder for that particular position in that field. So the combination, along with maybe there is expert opinion letter from Columbia University professor, that might help you overcome that doubt. So we need to bring this matter to the conclusion by not applying one rule, but the totality of the 4 pounds of the special and occupation rule. So your case is a success.
During a FDNS site visit, what documents and policies should an H-1B employer have ready to demonstrate compliance with the file petition?
You know, as I said before, H-1B FDNS site visit is going to be a normal occurrence without any announcement. They will go to your end client site, they will come to your site, they will go to the employee's home if they are working remotely. So anything is open and no need, the FDNS officer does not need to give you any notification. Luckily, the DOL officers at least they give you 24 hours in advance. Yeah, I'm coming to your place, have your public access file ready, your employment record ready, your payroll record ready, to analyze and the posting is there or not, right? But the FDNS officers are not doing that. Some, you know, if somebody is in from California to New York, then they might send the email. But most of the officers, they have offices in New York, even though his client site is wherever the client site is, the service center can send the file to that local office and the officer will pop in there. So as I told you before, FDNS H-1B compliance folder, please have that folder ready. If there is any problem, have your attorney, your immigration attorney review this. Both the public access file, compliance, FDNS compliance folder once a year. You review every 3 months. You self-audit whether there is a violation. Either amended petition has not been filed, LCA has not been posted, even though guy moved into the same MSA or within 50-mile radius. Do this exercise. The business requires your due diligence. This is not a time of blase giving it up like what used to happen under the Biden administration. Compliance is very, very critical under the Trump administration, or any time for that matter. Comply with the law. You will sleep better.
What are the red flags FDNS officers look for during site visits that could trigger a notice of intent to revoke or compliance action?
See, a VNS officer is coming, maybe there is already a red flag, right? When the employees are filing a complaint, or ex-employees are filing a complaint, or they may be council officers and refers for the VNS site visit, or it could be a random site visit. It could be a many sources. The origin could be from many sources. Nobody knows, right? So now, how to minimize this, right? How to minimize is you gotta do this audit, internal audit, and then find out what are your problems. Let's say you haven't paid the salary, guy isn't bent, run backwards, comply with the law. So at least, even though you made a mistake, you haven't posted the LCA, post the LCA. Even late post the LCA. You're doing due diligence. If you look at the case, there is a chemo technology case of New Jersey. The ARB decided under the chemo technology case, if a company has made multiple attempts to comply with the LCA posting rule, however, it failed to post, but it attempted. So there were mitigating factors to overcome this penalty. If this, see the LCA posting penalty is not only money, it has a 2-year debarment. So you cannot file a firm, H-1B, I-140, nothing for 2 years. So this is almost like a death sentence for IT consulting. So we do not need to be so blasé, but try to do this sub-audit or hire the attorney, let them do the audit, and then come clean, have this record, it will set you free because you are with the truth. Truth will set you free.
What steps should an H-1B employer take to ensure full LCA public access file compliance and prepare for a potential DOL wage and hour division audit?
Well, every company must have in the reception area outside of filing cabinet with the public access file. Sorry, public access file is going to consist of certified LCA, posting notices, both at your company and the end client side. And if you have not have it, under the demo technology rule, if you have made an attempt, how are you going to make an attempt? We're going to send the LCA or notice of posting to the end client manager by email. It's a one way I love you, even though you don't get a response, print that and put it in the public access file. That will help you to comply with the law, right? So, benefit summary and your posting, you have these along with the prevailing wage. The basic document. Put it in. The biggest thing you need to comply there is the employee's address changed? Did you file a amended petition? Did you file a new LCA? See, the funny thing here is every time a lot of my clients still call me when employee move to another location, even they go to Texas or they move 10 miles away, they want to file LCA. I say, don't file LCA. If you file an LCA, you must file an amended petition. Filing of LCA requires filing of amended petition. So if the guy moves within the same MSA, do not file an LCA. Force the old LCA in the new location, or force the notice of posting in the new location. Then you are in the compliance. You will be doing the right job. Put that into the public access. So be up to date, salary, posting, documentation. Employee must receive the certified LCA, get an acknowledgement receipt, and put it in that public access files. Everything is good.
What are the best practices to demonstrate that the degree requirement for a position is normal in the industry and not tailored just for the H-1B beneficiary?
Well, H-1B, it is a new phenomenon, right? The matching and specialty occupation under the H-1B Modernization Rule is a new thing for all of us to deal with. So my recommendation is make sure if you don't want to get this kind of NOID, which I just showed you before, if it's not directly matching the degree to the offered job, They're not issuing RFP and giving you 3 months to respond, but they are issuing NOID asking for directly related degree to the offered job. So we have an obligation to prove this element by virtue of either the academic directly related degree or a combination of degree with the ample amount of job experience in the related field. So that would assist the Homeland Security to approve this kind of complicated cases without any problem. Thank you. I think the questions are done. Is there any questions folks are asking, or everybody is happy with the presentation? Ladies and gentlemen, it's been an honor and pleasure to be with you today, and I'm looking forward to having this kind of webinar once a month, and we'll try later part of the month, so this month, and we're going to come in the part of May. So we're going to be engaging with you, and you can even send me the questions beforehand, and I can address those questions. I will incorporate it into my presentation, and this is going to be a new learning curve for all of us. New FDNS site protocols, H-1B Modernization Rule, all of these will survive. We survived Biden administration, Trump administration, Obama administration. I've been doing this since 99. So 99, we used to have one page, and we have still 2 days of I-129. And we didn't even write a page on that. We just put a program analyst job duties there. And 100% approved in 2 weeks. It sounds like a heaven. But here we are today, and together we can win. Thank you.